And besides that, nothing from us.
Mr. Goff.
Your Honor, 3, I think I'm counting correctly. One issue is we renew our objection and preserve it for the record to proceeding on Veterans Day. In this case, we maintain that under the Establishment Clause of the United States Constitution, any distinction under OCGA 141 between Sunday and federal holidays would be unconstitutional in this context. We would note, as this court has noted in the related context of compelling jurors to serve during COVID, compelling jurors to serve on this federal holiday, we would contend is a violation of the jurors' rights. Whether they have formally filed objections or not, we don't know whether they know. They can tell the court if they have an issue, like if they have daycare, but it takes on a different kind of context. We maintain that it is illegal. And in saying that, let me be clear. I'm not suggesting that this court doesn't value our veterans or value Veterans Day. We know how important that is to the court. But still, for preserving our objection, we contend that this is a notwithstanding the 1888 Supreme Court case that would be contrary to that this is not a judicial day when court can conduct business, and more specifically, this is a federal holiday on which the court cannot compel jurors to appear and for jurors to serve, however willing they might be to do that. That was one issue. I think the court's already addressed it, but I can sit down if the court feels compelled to address it again.
I believe I've already addressed that, and we're here.
We are indeed.
Yes.
The second issue, Your Honor, is my understanding is we're going to be taking up Special Agent Secret's statements or testimony later today. I may misunderstand.
The deposition is 4 hours with breaks. The state anticipates a 2:30 wrapping up of Larry English, and Officer Rash would be the next witness. I do not believe we will get beyond Officer Rash today into Special Agent Seacrest.
Okay. I can provide the information to the court. Because the court's going to be listening to a deposition for 4 hours, the court's respectfully already heard. I wanted to bring some matters to the court's attention, anticipating Agent Seacrest might testify tomorrow. Your Honor, there's an issue there with respect to the voluntariness of the statement made by Mr. Bryan. Statements in 511 and 513 to Officer Seacrest. Those were alluded to generally during the Jackson v. Dental hearing in this case. And much to my embarrassment, we did not follow up and actually file a brief on that subject. But I would like to apprise the court of 3 cases that...
I'm actually going to object at this point in time. Your Honor, we did have a Jackson Dental hearing on this matter. At that point in time, Mr. Goff was given a number of days to file his brief so that the state could file their brief in response to that. He is not ineffective because he and I spoke, and he said, I'm not going to pursue this issue. And he didn't pursue this issue. And now, in the midst of trial, he's bringing it up again. He's not ineffective. This is strategy. This is strategic. And the state objects to it because he did have his opportunity. We had an entire hearing, and he abandoned this knowingly and intelligently as part of his strategy. To bring it up now, of course, is additional strategy, and we ask that you not indulge him in this at this time.
If I may, Your Honor. We are now in trial. It doesn't matter what the court's ruling pre-trial is on the voluntariness of defendant's statements, because the jury independently during the trial must determine whether those statements are voluntary or not. Mr. Bryan is entitled as a matter of law to a charge on the admissibility of the statement. Now, even if he didn't, I believe co-counsel is going to be insisting on that charge. I'm maybe presuming, but there's a pattern charge on this subject. So,
I mean, the issue's out there, so I mean, the jury's going to be charged on it.
okay. So what I'm advising the court of is I think there are several cases that the court may wish to bear in mind as it relates to the examination of Agent Seacrest, both by the state and by the defense in this case, which obviously is going to be somewhat different than what the court's heard before. And it's going to impact the court's rulings. So if I may indulge the court with 3 citations.
Go ahead.
I've never known the court not to want to hear law. Griffin v. Strong, United States Court of Appeals for the 10th Circuit, 1993. 983 F. 2nd 1540. State v. Sanders, Supreme Court of New Mexico, 2000, 129 NM 728 or 13 P3D 460.
Mr. Goff, please slow down and can you repeat that?
I'm so sorry. State v. Sanders, Sanders, Supreme Court of New Mexico, 2000, 129, capital N period, capital M period 728, also reported at 13, P is in Pacific, 13 P3D 460. Last but not least, a case I'm sure the court is familiar with, Arizona v. Fulminante, Supreme Court of the United States, 499 U.S. 279, 1990. Whether threats by third parties are relevant for the jury's consideration as to the voluntariness of defendant's statements is a legitimate issue that the court will have to address. We also have the question as to whether these are truly entirely third-party threats or whether the state, whether the Georgia Bureau of Investigation fanned those flames on and prior to May 13th with their press releases. Certainly, the court might find a way to say that third-party threats are somehow not relevant, but to the extent that the Georgia Bureau of Investigation fanned the flames in this case with its press releases by former Cobb County District Attorney Dick Reynolds, then they're not necessarily third-party threats to the extent that the Georgia Bureau of Investigation aided and abetted the media storm surrounding Mr. Roddie Bryan prior to May 11th and prior to his statements on May 13th. Brings up a related issue, and I just want to make sure it's clear on the record. I filed lots of Brady motions in this case. I just want to make it clear. Our contention is under Brady v. Maryland that if there's any evidence in the possession of the state, that's not just the Cobb County District Attorney's Office. That includes the Georgia Bureau of Investigation. That includes the Attorney General's Office. That includes the Governor's Office. If there's any evidence out there that would suggest that the GBI played any role in fanning the media frenzy, fanning the flames in this case against Mr. Bryan in the days of and before the statements given to him by him to Agent Seacrest, then that is exculpatory information within the meaning of the Due Process Clause of the Fifth Amendment of the United States Constitution as incorporated by the 14th, and under Article 1, Section 1, Paragraph 1 of the Constitution of the state of Georgia. Whether Brady itself says that or not, we contend that is a good faith extension, not only of Brady, but of the Fifth Amendment authority upon which Brady is based. So we contend that all that information would be relevant, and to be fair to the state, this is not the kind of issue that comes up every day. Certainly before they begin their examination of the witnesses, I didn't want this to come up in the middle of it and have the jury shuttling in and shuttling out throughout that statement. Third issue, polygraph results. The state filed a motion prior to trial to prohibit any reference to polygraph results or I think by extension the polygraph examination itself. It was suggested at a prior hearing that the issue with respect to the admissibility of Roddie Bryan's statements was whether there was a quote-unquote deal in this case that he wouldn't be prosecuted. The problem is that when Agent Seacrest starts talking about what's going on behind the scenes, Mr. Bryan passed a polygraph examination that Agent Seacrest was notified of on the morning of May 13th. And that informs a variety of issues in this case, including if the state were to assert, as I believe they have in the past, that there was a change in Mr. Bryan's demeanor from the 11th to the 13th in his statements. That would be explained by the fact that he had just provided a polygraph result confirming most of the facts that we have elicited during the trial, such that he was unarmed, such that he was not in communication with the McMichaels. In the previous hearing, I think that going back through the transcript this morning at 4 a.m., the court might not be aware that there was an issue with respect to the release of the polygraph results, which in this case Mr. Bryan had on May 13th and had media trucks all around and withheld that information for 5 or 6 days waiting for the GBI to release it. And I think that it's important that the court understand that background when we start getting into the examination of agent secrets, because if the state isn't careful, they're going to open up some doors that perhaps they didn't intend to. And I didn't want the court to feel like you were getting ambushed, might not be the word for it, but surprised, because the tenor of the examination of agent secrets at trial could be substantially different than what took place in the Jackson v. Deno hearing. I have nothing more.
From the state? I'm not sure there's a motion out there because we've already litigated the polygraph issue. As far as these cases, I haven't had an opportunity to look at the cases. So I'm not sure, but I'll give the state an opportunity.
Yes, we've already litigated the polygraph issue. The law is very firm on it. Polygraphs do not come in the state of Georgia. They only come in if the defense and the state agree and the state does not agree. With regard to Agent Secrest, I believe what Mr. Goff is talking about is threats by third parties, and his complaint is that the GBI played any role in fanning the flames. So while those are convenient words, there isn't anything concrete there, meaning there's been no proffer that anyone from the GBI did anything, and I'm not sure what fanning the flames mean. What flames? What are we talking about? News media, news coverage, Mr. Bryan's statements? So once again, GBI, any role in fanning the flames is not a legal argument. And I don't even know what he's requesting for Brady versus Maryland, because as we all know, Mr. Goff was present when his client gave his statements. He was represented by counsel who was sitting right next to him during this entire interview, all the interviews with Agent Secrest. Agent Secrest had been in contact with Mr. Goff before, during, and after all of these interviews. So this assertion that somehow Mr. Bryan and his statements were, his demeanor changed because of outside influences that have absolutely nothing to do with the state, nothing to do with Agent Secrest, and the fact that he was represented by counsel, this appears to be a very empty motion, and there's nothing really at this time that the state can respond to. The state also has not had a chance to look at these cases, so I ask that this be deferred. And actually, I don't even know what he's motioning for. So.
Yeah, I don't think there's anything. I think this is more directory than anything else. Maybe it didn't come up in the context of the polygraph, but at some point in, I've got to think through this, in the pretrial, in the motion practice pretrial, the issue of what was surrounding Mr. Bryan's statement had come up. Was that not in the polygraph? Or was, I'm sorry, not in the discussion about the voluntariness of the statement that we're discussing?
Correct, it was during the Jackson Denner hearing, Your Honor.
The reason
so these are just some additional cases on that point.
The reason I raise it is because we're under no obligation. We're under no obligation to put the state on notice of anything, but we do have an obligation as officers of the court to keep the court advised as best we can. And I'm simply letting the court know that this issue during the trial could play out very differently than it did during the pretrial Jackson v. Deno hearing, and I didn't want the court to be surprised.
I understand. Thank you. All right, let me just go through this transcript charge and tailor it. It's me. Yeah, maybe if we could turn me down a little bit. I've just incorporated the prefatory language about the deposition into the charge transcript. So what I'm going to let them know is at this time, you're going to watch a recorded deposition. This is proper evidence for you to consider. During the deposition, some 911 calls will be played. I'm going to allow you to have a transcript of the recordings, and then I go into the charge itself that I read yesterday. So I'll go ahead and address it that way.
Your Honor, there's also a stipulation that's going to come in prior to the deposition. And the only thing I'd like to make sure we hash out is that the stipulation is something we all agree are the accurate dates of those 911 calls. And I know when you tell the jury, if you hear anything different, it's up to you to decide between a transcript and what you're hearing. But we want the jury to know that what the accurate dates of those 911 calls and the videos, the security cam videos that will be played during the English deposition, the accurate dates are what is on the stipulation. As the court may recall, Mr. English was understandably very squishy on remembering the dates, and that's why we agreed on the stipulation. So I just don't want those two issues to morph.
We join.
So you're entering into a stipulation on the dates of the 911 calls, dates and
Yes,
times?
it's very clear in the stipulation that we're,
Maybe I need to see it.
yes, and we've all signed it. It is going to be State's Exhibit 411. And I will hand you a copy. It is the fourth part of the stipulation there.
I believe it should be a joint exhibit, or a court exhibit, rather than a state's exhibit.
We join.
It's probably a court's exhibit.
That'd be fine.
Yeah, like we're on 3.
I'll relabel the front seven.
3, yeah, B court's 3. So at this point, is this being tendered in, the stipulation?
Yes, and I was going to read it to them this morning and tender it.
Okay. I understand there's no objection, it's a joint stipulation, court's 3 is in.
No objection.
No objection.
No objection.
Okay. So they're going to be coming out. I understand we'll announce the stipulation. I'll go ahead and give them the transcript charge and then also indicate that the parties are stipulating that within the stipulation, that these recordings occurred on certain dates and just remind them of what a stipulation is. Okay. Okay, I think we're ready? Okay. Okay, let's go get the panel.